Thank you very much for everyone for coming. In particular, thank you to Vice President Stavros Lambrinidis of the European Parliament. And thank you to our President, Joseph Borrell, for being here too. And in particular, thank you to Professor Harold Coe for accepting to give this lecture. I will make a very brief presentation of Professor Harold Coe, because I don't think much is needed. He's very well known. He's one of the most important scholars in international law and human rights. He has been Dean of Yale Law School for several years. He's the recipient of many awards and honorary doctoral degrees, but he also has a politics or policy career. Originally, if I'm not mistaken, in the Reagan administration, in the Department of Justice, then as an assistant Secretary of State for Human Rights and Democracy during the Clinton administration, and now currently he has been appointed by President Obama as the legal advisor of the State Department. So thank you very much, Harold, for coming, and the floor is yours.
Thank you very much, Miguel, and thank you all for coming today. When I was dean of the law school at Yale, someone told me that being the dean is like being the keeper of the cemetery, in that on the organizational chart there are many people below you, but there's no sign that any of them are paying any attention. So this is, for me, quite an honor to have the undivided attention of so many distinguished figures. I want to especially pay tribute to my friend, the brilliant Miguel Maduro, who is very lucky, you're very lucky to have him here, Martin Scheinin, who's made such a contribution in the area of human rights and terrorism, and then my student, Stavros Lambrinidis, who, while he looks pretty much the same as he did when he was in my class, has risen to a position of great distinction within the European Parliament. And thank you, Mr. President, for this invitation. What I wanted to do was to give you a sense. For 30 years I have been working in this field, and as Miguel suggests, I have three perspectives on this subject: as an academic, scholar, a teacher, and dean, as a human rights lawyer and policymaker, and then as a government official. I worked in the Justice Department of the Reagan administration in the 80s. I was Assistant Secretary for Human Rights in the Clinton administration in the 90s, and now legal advisor for the Obama administration in the 21st century. The job which I have, legal advisor of the State Department, I had a law firm, public international law firm of about 180 lawyers called L, and we play four roles. We are the counselor of the State Department in general counsel, so we do what other lawyers for the government do. We buy buildings, they happen to be in Kabul. We negotiate contracts, they happen to be in Baghdad. We work on issues of diplomatic immunity, consular immunity. But the second function, I think, is a broader one, which is to be the conscience of the US government with regard to international law. This requires also that we defend US interests in various settings. And so I've appeared on behalf of the US at the International Court of Justice in the Kosovo case, the North American Free Trade Agreement arbitration panel in the Grand River case. We are debating the question of what role to play, if any, in the European Court of Justice with regard to sanctions. I regularly sign or engage on briefs before the US courts on issues of international and foreign relations law. We appear before the Iran-US Claims Tribunal, and we coordinate activities before all of the tribunals, including the International Criminal Court, the Yugoslav Tribunal, Rwanda, Sierra Leone, Cambodia, etc. And then fourth and finally, a role of the legal advisor is to be a spokesperson for the US on our relationship to international law. It's an unusually academic position. There are 22 legal advisors. This year happens to be our 80th birthday. We were founded by Congress in 1931 on February 23rd. In fact, we have existed since 1848. But the relationship between the legal advisor's office and the international legal community gives what I think is an important duty of explanation with regard to past and proposed actions. So these roles and three perspectives, I think, have given me the opportunity to consider two questions. The first, obviously, is has the Obama administration's approach to international law been change we can believe in? I notice the global governance program says ideas change. And if you read the blogosphere, you would conclude that both the right and left of the political spectrum see no difference between the Obama administration's approach to international law and the Bush administration's. The right argues there's no change, but continuity we can believe in. The left argues they see no change, and because they see no change, they don't believe. I think that when the entire blogosphere agrees for diametrically opposite reasons, it's probably wrong. And that's my central thesis today. Now, there's a second question, which many here in Europe are often asking, which is there a peculiarly American form of international law? Is there an international law approach that Americans can believe in, that non-Americans can understand, that's distinctively American insofar as it's within the margin of appreciation, but that's consistent with American values like the Constitution, democracy, and limited government, as well as emerging global understandings. And I am on my way to Strasbourg tomorrow morning and then to Geneva, where I will be concluding our presentation before the UN Human Rights Council. At the UN Human Rights Council, as you may know, the United States had not been a member. Under this administration, it re-engaged. More on that in a moment. And then we do a universal periodic review in which we receive recommendations from other countries. Many countries receive 1 or 2 recommendations. We received 228, which is twice as many as the nearest competitor, namely Sweden. Now, it's interesting because when you look at the recommendations we receive, they show that there are at least 7 areas in which those who ask us questions have a different perspective on international law than do Americans. And I think it's worth highlighting those, because they're often not obvious to those on this side of the Atlantic. The first is the approach to treaties. Many European countries or other countries take a perspective of what I would call ratification before compliance. Let's face it, many countries have ratified these human rights treaties, are not even close to being in compliance. And their criticism of the United States is that we have not ratified these treaties, when in fact our compliance record may well be better. So one obvious question is compliance versus ratification before compliance. This is a philosophical difference. A second is the approach to the death penalty. I am personally opposed to the death penalty. I've said this, I've litigated against the death penalty. Nevertheless, I do not believe that the death penalty, fairly administered, violates international law. I believe that there's a standard emerging, particularly here in Europe, which opposes the death penalty and would like it to violate international law. But at this moment, I think fundamentally there's a difference of policy on this position. The United States has in recent years struck down various manifestations of the death penalty, the execution of minors, the execution of persons with mental retardation. I think at the core, which is does the practice of the death penalty, which by the way is mentioned in the ICCPR specifically as a form of judicial as opposed to extrajudicial execution, still is consistent with international law rules. There's a different standard emerging, but I think the difference is a policy difference and not a legal difference. Or take a third, an approach to economic, social, and cultural rights. This is obviously a famous difference, as you see, for example, in our debates over healthcare. Franklin Delano Roosevelt in 1941 mentioned freedom from want as a kind of right, but in fact the United States has signed but not ratified the International Covenant on Economic and Social and Cultural Rights. There's a difference in approach to domestic implementation. Many non-American approaches focus on national and regional human rights institutions. The US approach tends to focus on the existing institutions of the federal government, judicial, legislative, and executive. With regard to foreign law, there's a debate over the extent to which foreign law ought to be applied as a matter of domestic jurisprudence. When I say a difference between the United States and Europe, it also includes, obviously, Canada, Israel, and other countries. There's a difference in approach to freedom of expression and religion. The United States tends to be more tolerant with respect to issues like hate speech. And then finally, seventh, there's a difference in approach to national security, as expressed most recently in what I think was a wave of protests against the Bush administration policies regarding treatment, international humanitarian law, Guantanamo, privacy, and what was called the global war on terror. I mentioned these 7 differences to show that we can all believe in a concept of international law and have disagreements about the particular conceptions of international law. And that doesn't necessarily make either side's approach illegitimate. Now, I've written about what I call 5 faces of American exceptionalism in an article in 2003 in the Stanford Law Review. And I tried to distinguish between 5 kinds of exceptionalism. Many criticize American exceptionalism. I think of it like cholesterol. There's good and bad cholesterol. In the same way, there's good and bad exceptionalism. Because the United States is at its worst when it's promoting double standards. It's at its best when I think it's engaging in exceptional human rights leadership. And for those who say America is the problem, it forgets the times in which America is the solution, and frankly, without America, there is no solution. And I think we have to be aware of this, the importance of American participation in the international human rights and rule of law system for that system to work. Now, in our Supreme Court, there is a famous debate going on now about nationalism versus transnationalism. That's more of a parochial debate, but of great interest. Second, we have a distinctive rights culture, particularly with regard to freedom of expression. Sometimes we use different labels for the same terms. For example, our statistics on police activity do not include the word torture. They use the word police brutality. Now, this is a label difference. It's not a conceptual difference. So it's not an example of exceptionalism. It's an example of the lack of a integrated terminology. Louis Henkin, the great late professor of Columbia Law School, referred to what he called the flying buttress mentality, the notion that in the cathedral of human rights, the United States is often a flying buttress outside the structure supporting it, but refusing to enter in. And this is another face of exceptionalism. But I think that for me, the most important difference, and the one worth exploring, is double standards. To what extent is the US actually urging a different standard for itself than for others? That I would call bad exceptionalism. I don't think that's consistent with the universal rule of human rights or international law. On the other hand, exceptional leadership does not necessarily require double standards. So with regard to this question, is there an American international law? I would ask, is this approach that's emerging on the bad side of the line or on the acceptable side of the line, is it consistent with global understandings and the margin of appreciation? Is there an approach that Americans can find consistent with American values of constitution, democracy, and limited government? Now, these 2 questions, have we seen change we can believe in? And is there a distinctively American international law? I think is relevant to 3 debates: academic, judicial, and policy. On the academic side, in both the American left and the American right, there are those who say that American international law approaches is inconsistent with emerging European understandings. My colleague Jed Rubenfeld at Yale is an example of someone who takes this position from the left. Jack Goldsmith of Harvard and those called the New Sovereigntists take this position from the right. Customary international law, they claim, is somehow inconsistent with core American values. I think this is an odd position given that the United States was founded and the Constitution created in 1789 around the notion of decent respect for the opinions of mankind and based on the notion that courts would find customary law. So it's a very late in the day to discover that what we have been doing since the beginning of the US Republic is inconsistent with core American values. But anyway, that's an academic debate. There's a judicial debate. I've mentioned the debate between the right and left wings of the US Supreme Court on the question of application of foreign law. Right now, the swing vote is Justice Anthony Kennedy. This has happened to crop up, particularly in the context of the death penalty, the war on terror, and in same-sex sodomy cases, Lawrence versus Texas, which happens to be the first case in which the US Supreme Court cited to a precedent of the European Court of Human Rights. It's also going on in the lower courts, a case not widely seen, but which is a very important one, Bahani versus Obama. The question was whether international law informs US authority to detain in an armed conflict under the Authorization of Use of Military Force resolution. The panel, composed of two conservative judges, among others, said that international law did not apply, but when it went to the full court, they rejected this analysis. So there's an ongoing battle going on within the same lower court, and my guess it will eventually make its way to the Supreme Court. Finally, it seems to me that in the policy debate over national security, you can never eliminate all differences of view, but there should be a reasonable discourse about where we differ. And I would argue, as I've suggested, that both the extreme left and right are wrong on this issue. I align myself with someone called Jon Stewart, the leader of the Million Moderate March, who believes there is a change in our approach. I believe there's a change. I don't know if I don't attribute it to Jon Stewart. There is change to our approach to international law, that we need to keep working for it, and to sustain an American international law with legitimacy at home and acceptability abroad, we need a calmer civil discussion to reduce polarization, two kinds. Polarization between two US and foreign attitudes toward international law and between the American left and the American right. So another title for this remark could be just simply reducing polarization, and how can that be achieved? So let me ask you three questions and then try to answer them. Just to give you a flavor, the answer to all three questions, I will tell you, is yes. So does the Obama administration have, I think, a coherent and sustainable legal and policy approach to our policies? Yes. I think, have we brought change to the US approach to international law? I think yes. And does that explain our actions with respect to 9/11, international law, international institutions, international engagement, especially treaties? And I would argue yes. So let me make this case, and then I'm happy to answer your questions. Let me begin with the president's approach both during the campaign and in his first 2 years of office. A new era of engagement has begun in this era. Living our values, he said, doesn't make us weaker, it makes us safer, and it makes us stronger. This is a consistent theme of this president in a series of speeches he's given at the National Archives, his Nobel lecture, his Cairo speech, his speech in Warsaw with regard to nuclear weapons. Secretary Clinton, my boss, has said much the same. We need to apply smart power, a full range of tools, including the legal tool. Respect for law is an essential element of our smart power, and intense creative diplomacy must be accompanied by intense lawyering, which I think leads to an emerging Obama-Clinton doctrine, which has four elements: principled engagement, diplomacy as a critical element of smart power, strategic multilateralism, and living our values, following rules of law, domestic and international, and following universal, not double standards. Now, those who believe that, in fact, this has not been the guiding principle, I say we're 2 years into an administration that we hope runs for 8 years. It's, I think, unfair to compare an administration that has served for 8 years with one that served for 2 years, but the guidelines of our positions are now emerging, and let me go through them. In particular settings, first, Guantanamo. Is the United States still committed to closing Guantanamo? Second, with respect to the armed conflict with al-Qaeda, are there changes between this administration and the Bush administration regarding the question of whether to detain, detainability, how to detain, humane treatment, who to use force against, targeting, the use of legal engagement with regard to the International Criminal Court and the Human Rights Council? And I would say that our overriding commitment has been simple. We are committed to complying with all applicable law, including the laws of war, in all aspects of these ongoing armed conflicts, full stop. With regard to Afghanistan, Iraq against al-Qaeda, detention operations and targeting, consistent with both the applicable laws of war and the Constitution laws of the United States. When this ends, I will resign. But for now, this is something which this administration, I think, has done a good job keeping a focus upon. And President Obama has made this point in 2 major speeches, one before the National Archives in May 2009, where he says, we are at war with al-Qaeda and its affiliates. We need to update our institutions with abiding confidence in the rule of law and due process. When he received the Nobel Prize, he said, where force is necessary, we have a moral and strategic interest in certain rules, and the U.S. must remain a standard bearer in the conduct of that war. So the Archives framework has 4 pieces, not 1, 4 pieces. And when I travel around the world, the thing that shocks me is how few people understand these 4 basic pieces. These were set forth in May 2009. These have not changed. They were set forth in May 2009. There are 4 pieces. It is a package. I repeat, these are 4 pieces. And the next time you read a story about one of them, ask what's going on with the other 3. Number 1, where possible and feasible, we try those who have violated criminal law in federal court. In some cases, we may need to use revised military commissions, and the laws have been amended. Third, from Guantanamo, we will transfer those who can be safely transferred. And fourth, where there are no other options, we will continue detention under the laws of war and consistent with the principles of the laws of war. Now, last Monday, the administration reaffirmed this framework. To, I should say, much criticism and little understanding, all the administration said was, 1, we remain committed to civilian trials. 2, we will resume military commissions on Guantanamo for now until it's closed. 3, we will continue transfers consistent with the law. 4th, with regard to prolonged detention, we will have an executive order on periodic review. And we will strengthen humanitarian treatment guarantees by supporting the advice and consent to additional Protocol 2 of the Geneva Conventions, and henceforth comply with Article 75, Additional Protocol 1 on humane treatment, which is the successor provision to Common Article 3, out of a sense of legal obligation. So this is simply reaffirming the basic elements of the Archive speech. Now, Guantanamo remains open. This is a disappointment. My point is a very simple one. You could close Guantanamo tomorrow by abandoning these principles. The important thing to me is that the principles be applied in the way that Guantanamo is closed. As of today, the numbers are down from 242 at the beginning of the administration. 172 remain. 59 are approved for transfers. Some 57 Yemenis are there, which is a peculiar situation, as you know, and now made even more complicated by the unrest in Yemen. 36 have been referred for prosecution either to Article 3 courts or military commissions. 47 have been designated for continued law of war detention. 67 have been transferred. 1 has been tried and sentenced to life imprisonment. Now, the president said we remain committed to closing Guantanamo. It's not for lack of trying. The politics are different. Those who ask, why haven't we closed Guantanamo yet? It's pretty simple. The president can't close Guantanamo by himself. We need help from our allies. They have been very stalwart, but most allies have taken one or two. Congress has been very restrictive in imposing legislative restrictions and is prepared to impose more. All of these cases are before the courts. But closing Guantanamo remains a commitment of the administration. We believe that it is a negative symbol. It remains a tool for recruitment, and we think that terrorism prosecutions in Article III courts have succeeded. The Richard Reed case, the Al-Mari case, Padilla, the Zazi case, Shahzad, Gailani are all examples that our civilian courts work. Now, we are facing a series of legislative restrictions. The latest have been enacted in the last, or have been introduced in the last week by Senators Graham and McKeon. In my adult lifetime, this is the most difficult political environment that I've seen in Washington, and it imposes a series of possible restrictions, which I think will again make the politics even more complicated. So the speed of closure may not be what we want. The important thing is sticking by the framework. What about detention operations? Here, we have interpreted the scope of detention authority as authorized by the US Congress and as informed by the laws of war. We are not relying on the president's inherent authority as commander-in-chief, which was the pattern under the last administration. Humane treatment is the most obvious difference. When people say they see no difference between the Obama administration and the Bush administration, I would ask you, where is there proof of inhumane treatment by this administration? And the answer is there are no examples because it has been eliminated. And that in fact, all interrogations must now be conducted consistent with Common Article 3. The US has made it even clearer in the last week that it will seek advice and consent to the Additional Protocol 2 and will comply with Additional Protocol 1, Article 75, as opinio juris. Now, it turns out that as a matter of international law, we believe that certain basic principles remain. We are fighting a war of self-defense with Afghanistan. We have a consenting partner. The UN Security Council has authorized all necessary measures to fulfill the mandate. We comply with the laws of war, but detention of enemy belligerents is a permitted feature of armed conflict. And our general approach is to look to functional membership in an armed group, which is consistent with the position taken by the International Committee of the Red Cross in its direct participation hostilities study. Our courts, as I mentioned, have largely accepted this theory. They have disagreed with other aspects, but they agree that we can detain individuals who have been joined with or part of al-Qaeda and the Taliban and associated forces if this can be demonstrated by indicia of membership. And as I mentioned in the al-Bahani case, two members of the court said international law did not inform the scope of authority, but this seems to me inconsistent. If international law is the basis of our detention authority, how can it also not limit that authority? So let me review this so you get this clear. There are 6 ways in which this administration differs from its predecessors. They may not seem to you earth-shaking, but they are important. With regard to humane treatment, there's an absolute ban on torture, cruel, inhuman, or degrading treatment, and a new commitment, as I've mentioned. With regard to domestic law, we rely on legislative, not inherent authority for detainability. With regard to international law, we read the domestic law consistent with international law rules. In the last administration, it was the executive branch that tried to evade international law and the courts that was urging them not to. And this administration, it's the executive branch that's seeking to comply and the courts that are urging it not to. We do not use only a law of war paradigm. We combine an approach to the armed conflict issues that includes law enforcement when law enforcement capacities exist. So if a terrorist suspect is in Florence, we would rely on law enforcement methods to secure and capture that person. But that's quite a different situation if they're in an area which is an ungoverned territory. This administration does not use the term global war on terror. You have not heard it. We support only those actions that are authorized by law. We acknowledge that particular issues arise not just in Afghanistan and Iraq, but in other areas. And so, for example, the precise geographic scope of the conflict can be debated. And finally, we do not rely on labels like enemy combatant to justify someone's detention. We make a factual case with regard to particular individuals applying law of war analysis about their formal or functional membership in Al-Qaeda and associated organizations. And as a professor, one of the things that has surprised me the most is the extent to which every single person being held, their detention is being justified under an application of a legal theory of detainability to facts that are on the public record and which were developed by detention task force that went to work on January 2009. It is a fact-based, specific inquiry, not a label-based inquiry. These are important differences and widely ignored or misunderstood in other parts of the world. Now, some say that our targeting practices have been an exception. And as you may know, my view is that they are not. I have spent a large amount of time examining these targeting practices, being briefed in those practices. As I say, including operations involving unmanned aerial vehicles. The U.S. remains in an armed conflict with Al-Qaeda, the Taliban, and associated forces. We are exercising both an inherent right of self-defense, and there are 5 recent failed efforts to attack the United States within the territorial United States in the last year. Congress has authorized the use of force in such cases under the Authorization of Use of Military Force resolution. And in this conflict, we have authority, it seems to me, to engage in such activities, including targeting persons who are planning these attacks. Where can this be done? It's obviously a fact-based inquiry, which turns on issues such as sovereignty, willingness and ability of states to suppress, and the imminence of the threat. We take great care to adhere to the laws of war and to apply the principles of distinction and proportionality to make sure that legitimate targets are being singled out and that proportional force is being used. And on this, it seems that there are 4 basic points. It is not illegal to target a leader of an armed force in an armed conflict. After Pearl Harbor, there was an effort made and successful to target the Japanese general who had actually planned that attack and was planning the next attack. That is a permitted activity under the laws of war. It's not illegal to use advanced weapons systems any more than it was illegal to shift from the crossbow to the crossbow from the spear or to smart bombs or other weapons which increase the accuracy of targeting. And as a result of that, it seems to me to limit collateral damage. Third, it is not extrajudicial killing to use these methods to target particular individuals in the course of an armed conflict. No nation state issues its target lists, nor is this a judicial process which is used in the context of warfare. If this is a legitimate armed conflict, and I firmly believe that it is, we are not applying a judicial paradigm. And finally, it is not assassination. Under our domestic law, the use of lawful weapon systems consistent with the laws of war for precision targeting of specific high-level belligerent leaders acting in self-defense or during an armed conflict is not unlawful, and it's not assassination. Now, in sum, with respect to targeting as well as detention, detainability, and treatment, we're committed to assuring that our practices are lawful. Now, in the time remaining, let me mention a number of other areas to suggest that this is only one feature of our approach. Closer engagement with the International Criminal Court, closer engagement with the Human Rights Council, activity on international treaties, and other kinds of commitments to international law, particularly with regard to international legal appointments. We have had a tangled history with the International Criminal Court. Nobody needs to be reminded of this. The U.S. prosecuted war crimes at Tokyo and Nuremberg, promoted the concept of International Criminal Court in 1995, Bill Clinton favored the concept of an international criminal court, but the U.S. did not sign the Rome Treaty in 1998. He did sign before the end of his time in office. President Bush famously unsigned that treaty. The court came into force, but by the second Bush term, the United States did not vote against the referral of the Sudan case. By 2008, my predecessor had said we accept the reality of the court. In 2010, I led the U.S. delegation to the Kampala Review Conference, and 2 weeks ago, the United States voted for a unanimous referral on Libya to the ICC. So what we have done is shift the default from a policy of hostility to a more productive policy of engagement. We've ended our hostility toward the court. We meet with members of the Assembly of States parties. We meet with officials to examine ways we might assist in ongoing cases, Sudan, Congo, Central African Republic, and Kenya. And we supported the work of the Kampala Review Conference, which is subject to further review of the crime of aggression by 2017. There are still remaining areas of concern: the definition of the crime of aggression, the conditions for asserting jurisdiction, the amendment process, but these are all ones in which we are now productively engaged. The key question right now is, if you have not ratified the new aggression amendments, are you a party or not? The text of the Rome Statute, Article 121.5, says pretty clearly, the court shall not exercise jurisdiction when committed regarding a crime covered by the amendment when committed by that state's party or on its territory. And it seems to me this would exclude those who have not ratified. But this is a subject in which the states parties are having a substantial debate even as we speak. The Human Rights Council, where I'm headed on Friday, is an institution that we rejoined more than a year ago to extensive criticism, particularly focused on the Goldstone report. While people weren't paying attention, the Human Rights Council has begun to become quite successful. We're completing our first universal periodic review. They had a special session where they created a commission of inquiry on Libya. There's a new special rapporteur on freedom of association, a working group on discrimination against women. Mandates have been renewed on Sudan, Haiti, Cambodia, Somalia. A Cuban initiative to undermine the Office of the High Commissioner has been prevented. And the High Commissioner and the Special Rapporteur have been meeting to discuss issues in the Republic of the Congo. What about treaties? We're in a very difficult situation in our Senate. The President's party has only 50-some votes and needs 67 to ratify a treaty. Nevertheless, at the end of the last year, we ratified the START Treaty, some tax treaties, defense trade treaties with the UK and Australia, child support conventions. We've held hearings on the Women's Rights Convention. We just urged advice and consent to additional Protocol 2 of the Geneva Conventions. And I remain optimistic that the Senate will act favorably on the Law of the Sea Convention, the Disabilities Convention, private international law treaties, and others. Another area where we have made what I think are very low visibility changes are in our appointments to international bodies. These are individuals who will long outlive this administration. Joan Donahue, my former principal deputy, is now the Judge of American Nationality on the International Court of Justice. The brilliant Gerald Newman, U.S. expert on the Human Rights Committee. Jim Brudney is the new expert on the International Legal Organizations Committee of Experts. Sarah Cleveland, who will be arriving shortly, is the U.S. representative on the Venice Commission. Tim Feary, the new chair of the Foreign Claims Settlement Commission. We have announced that we are engaging on the International Law Commission, nominating Sean Murphy to run. These are very different figures than served on these bodies in the past. So, in sum, I would argue, and I have other areas to mention, in the areas of the laws of war, the areas of official immunity, the Samantar case, treaty interpretation, our pending legislation to comply with the International Court of Justice's judgment in Avena, our new attitude toward the International Criminal Court, the Human Rights Council, Kyoto, our appointment of international legal experts. Now, I would just make a simple point. All of this is going on against a background of enormous challenges. There's a story about two guys from Galway, and one of them says to the other, "How do you get to Dublin?" And the other says, "I wouldn't start from here." Well, if you were in the position of the Obama administration and trying to make these changes with regard to international law, would you start with the worst recession since the Depression, armed conflicts in Iraq, Afghanistan against al-Qaeda, the worst political environment in history, a crisis in the Middle East that now laps over Egypt, Tunisia, Bahrain, Yemen, Libya, Oman, and others, a revival of old challenges like piracy in the Gulf of Aden, diplomatic immunity, and a whole series of new challenges from the 21st century, climate change, shifts in the polar environment, cyber issues with regard to crime, security, aggression, terrorism, food security, food health, and then throw in a 9.0 earthquake in Japan, a 7.8 earthquake in Haiti, one in Chile, a nuclear crisis in Japan, volcanic ash in Iceland, a massive oil spill in the Gulf of Mexico. You know, you just might say, I wouldn't start from here either. But having said that, I think I've made the case. We have a coherent and sustainable legal policy approach. It explains our approach in the areas I've described: 9/11, international law, international institutions, treaties, international appointments. I think these are changes and changes we can believe in. And I will say this: this has not been easy, but I do not believe these are small accomplishments. Now, this, I think, is an international law that reflects American distinctiveness, falls within the margin of appreciation, is consistent with emerging global understandings, and is consistent with American values. And let me close with this story. Before I became a law student or pre-law student, I was a physics student. And we had an experiment, in fact, shown by this glass of water, this vial of water, in which my professor showed that the water had been ionized, and he put a series of steel needles on the water, and they were pointing in a whole bunch of different directions. And then he took a machine and he waved it over the machine. And everyone said, "There's no change. There's no change." And then he dropped the needles in again, and they were all aligned. And he said to us, "This is a water vortex magnetizer. It treats water magnetically. It transfers a natural vibrational imprint onto the water through what he calls vortex ion exchange." And then he said the most important thing: "You can't see it, but this is change." And it's necessary change. We have reversed the polarity of the ions at the molecular level. We have reduced surface tension. We've inhibited the growth of bacteria. And this is the necessary step to everything we want to do ahead. So to promote change, it seems to me we need to do the same, to patiently reduce polarity, and to continue on the efforts begun and on which I work every day. Thank you.